So today we're going to talk about how to be an effective listing agent. Some hot topics for listing agents. Now let's get into it. So if you've been here before, you know. If you're new to us, here's our mission and our theme. This is why we come together each Tuesday really quickly. The mission of Title Tuesdays is to provide a weekly coaching call for realtors to discuss the latest trends and need to know information to grow your business. Right? We just if you know something, it's going to help you propel your business forward. All right, somebody found some rocket ships. I love it. So, here's what occurred to me. So I get a lot of questions all the time about different contract issues. Obviously, I should. I'm an attorney. Closing issues, I should. I'm a closing attorney. And I said, you know what? And some of those questions, they almost come sometimes in desperation, right? And I say, well, hold on a minute. Like, there's a resolve. There's an answer to that. There's something that we can do to work around that. And so it came to mind, and I said to the realtor that I was speaking with, I said, you know what? When you encounter an issue that impedes your forward progress, you have not reached the dead end. You have not reached a dead end. You have simply reached the extent of your knowledge. So you've done the right thing by reaching out and looking for assistance with this thing. But it only means that you've reached the extent of your knowledge, as much as you know to move this thing forward. And so ultimately, what we understand that we have to do, you just simply have to learn more to earn more. That is the secret to success. Learn more to earn more. Again, I'm going to tap back into Mr. Jeff Bezos. Mr. Jeff Bezos is a bona fide billionaire. He is a bona fide billionaire. And what's the difference between him and someone else who's a bona fide hundredaire? It's simply knowledge, right? It's knowledge and then application of knowledge. But because there's probably some very intelligent people that are probably smarter than Mr. Bezos, but they did not apply that knowledge in order to gain this type of success. So at the end of the day, we come together to learn more so that you can earn more. Now, if you landed here, you don't know how you got here, somebody pulled you in, the final frontier, that's right. If someone pulled you in, you're like, who is Title Experts? I just kind of saw an invite and I'm here. We are, just a little bit about us. We are an attorney founded and operated title insurance and settlement firm. We believe that we are the epitome of a five-star closing experience. We developed Title Experts not to just be another title and settlement services firm, but to provide an experience that your clients and you will enjoy. Our endeavor is to be the most knowledgeable and reliable settlement and lightning. I don't know if you guys saw that flash. The most knowledgeable, reliable settlement firm in the industry. We're going to the moon with this thing, right? And so the benefits of working with Title Experts, if you are not familiar, is we're attorney managed firm. We provide a dedicated closing team. We provide weekly status updates. We provide helpful closing guides. And finally, rush processing is available. At the end of the day, I'm excited about my local team here in the office that I'm in right now. This is some of your closing team when you work with us. If you if you don't have our contact information and you're looking to working with us, you send new contracts to contracts@titleexperts.com. If you have general questions, you send those questions to closings@titleexperts.com, and you can call us anywhere from our 800 number, 866-5-experts. We're proud of that number. Shout out to my closing team. They make me look good. You guys know that you can never do all this by yourself. And so appreciate those little frontline warriors there. Now, for those who I have not had an opportunity to meet before, hi, welcome. And for those who I've seen before, you're back, welcome back. A little bit about myself. My name is Ray Cole Jackson. I am a real estate attorney. I obtained my undergraduate degree from the University of Florida. Say it all with me, go Gators. If you are a Knoll, save that for your presentation. I obtained my law degree from Santa Clara University School of Law. I came back home. I am originally from Miami, Florida, and obtained my LLM in real property development from the University of Miami School of Law. And so secondarily, right, we can say that. Secondarily, go Canes. And then finally, while in law school in California, I did obtain my real estate license in California. And then moving back here to Florida, I obtained my real estate license here in Florida. So I am a licensed real estate salesperson. The reason why I provide this information is because oftentimes, realtors say, oh God, here comes the attorney. They're just going to kill the deal. You don't understand. You don't understand what we're going through. Yes, I do. Yes, I do. Listen, I did transactions. I started out on the commercial side. And then when the market turned, like we all did, got into distressed sales and representing investors, moved into foreclosure, moved back into real estate transactions when the market started returning. And so, but my point is, you have not signed a document. You have not had a conversation. You have not had an issue. Most issues, some things I always say, listen, we learn something new every day. The strangest things can happen, but most things that you have experienced, I have as well. And so that's why I bring these conversations together. It's not just for information, but for relevant and applicable conversation. So let's get into our discussion for the day. Hot topics for listing agents. So this conversation, it was born out of frequent questions that I get from realtors when they're representing sellers, and also some issues that arise on the listing side. And so I said, well, why not have a conversation about some of the things that you guys should look out for, the hot topics that you should consider when you're operating as the listing agent in a particular transaction. I know that most of you, we know that listings are leverage, and if you had your way, you would only do listing side. But the reality is we operate on both sides of the table as necessary. So today we're going to have a conversation about what you need to be mindful of when you're representing sellers as a listing agent. So we got 10 things that we're talking about. We're just going to have a conversation. You guys know that you'll get this recording I guess within 24 hours, and it's also posted on our YouTube channel. So be sure to subscribe to our YouTube channel. But the point is, I want you guys to listen, take this in. Don't try to take too many notes. You can always go back to the replay and take notes. One of the first things I want you to be clear on as you begin this transaction process is, who is your seller? Who is your seller? Now that may sound easy, that may sound apparent, but consider, you understand that the only person that is required to sell is the person that's under contract. So you want to be sure that all of your sellers are, Dave raised the hand. Dave, hit me in the chat, because I got like 4 things I got to look at. Look at chat, look at the entrance, and look at the presentation. So Dave, feel free to drop a note in the chat, or in everybody, in lieu of raising your hand, if you have a question. If you have a question and you're not just waving, if you're just waving, hi. So who is your seller? So one of the most basic ways to do this is you can go and look at the property appraisers page. Who is shown as the seller? Who's shown as the owner of the property on the county property appraisers page? Those are the people that you should be looking for to sign your listing agreement and your contract, right? You have, let's say, for example, you're moving fast. Oh my God, this guy says he's gonna list his property with me in this market. We already know as soon as it goes up, I'm gonna get 50 offers and we'll be under contract in 12 hours. He said he's ready. I just went and got him to sign a listing agreement. We got an offer, he signed. It gets all the way to title, and title says, well, Mr. John Smith is married to Jane Smith. Where is she? Right? And you say, what? John, he said he's the only one that owns this property. No, there's someone else that owns this property, Jane Smith, and Jane Smith needs to execute the closing documents. That's a very simple one, but it happens. How about when it was the estate of? You know that the owner is deceased. Who is the appropriate person? Who is your seller? Who is signing? Well, we know that when you go under contract, generally you're going to have the personal representative. You could have a court document that's already identified who that personal representative is, or you can have a person that's saying, listen, I'm an only child, that was my mom, there's no one else. And you can take their word for it. Once you get to title commitment, it's going to absolutely tell you who should be signing, because you should have, by that point, you would have gone through the probate process. So here's what I need you to know when you're dealing with that estate property. Where are you in the process of the probate? Are you at the very beginning? If you are, Factor in the time that it's going to take to get through to final order of sale, right? Again, that this is not one that's going to go under contract in 12 days and sign and close in 21. You're just at the initiation of a probate process. So be mindful of that. Now, if you're further down the road, again, that may be a little less time, but we have had situations where a contract with an estate seller, the timing of it has been, the realtor thought it would be the same as with individuals who are not in an estate, and that's just simply not the case. So next week we're talking about hot topics for buyer agents. So buyer agents need to be aware as well that you're not going to the closing table in 21 days if this property is just starting its probate process, right? So who is your seller? Let's be clear on that. That's point number one. Working our way through the contract, what is the next thing you want to be certain on? What personal property is not being sold? We talk about this very often when we do the contract class, but do you guys believe that we still have this issue? The chandelier is a light fixture, guys. What does it say here? Oh, hold on one second, because hold on one second, because I see that y'all got control to annotate my slides. Right here we see, let's shift to a contract class really quickly. Line 15 of the FAR bar as is contract says, unless excluded in paragraph 1E, which is down here, or by other terms of this contract, the following items which are owned by the seller and existing on the property as of the date of the initial offer. This is what you have to understand. When the buyer goes and walks through that property and they make an offer, that is the state of the property that they expect at closing. If there's light fixtures in there, that's what they want to see when they close. If it's Viking appliances in there, that's what needs to be in there. Again, you're going to add it into the contract when you close. The doors, stranger things have happened. You can't go and change these nice doors to contractor grade doors, right? Whatever the buyer sees when they go under contract is what they expect to be in the property when you close. It can't be 2 days down the road and they're like, seller wanted to take her front door. See, yesterday, 6,000. Yep. Well, it is. It's part of the property. It's part of the property. Doors, I mean, come on. Some people ask questions like, is the TV a fixture? Doors are, in fact, part of the property to be conveyed. No one expects you to remove the front doors, right? So the seller, that's a good question, Gino. Those doors need to go. Those doors need to go. So the following items which are owned by the seller and existing on the property as the date of the initial offer are included in the purchase. And so then it goes into those lists of items: the stove, the refrigerator, the dishwasher, the disposal, ceiling fans, intercom, light fixtures. Light fixtures I point out because that's the most common misconception. That chandelier, if it's not going, make sure you include it down here in excluded. Make sure that you point out that it's excluded, because if not, you have to have a conversation with your seller and say, I'm sorry, it's going. It's going because we did not exclude it. So don't miss this. When you walk through and you're preparing for this property to go on market, you ask the seller, what absolutely is not staying here? What are you taking with you? Again, based on your knowledge of the contract of what's going. So specifically those chandeliers, these are beautiful chandeliers, Mr. Seller. Do you intend to convey these when we close? Or do you want to take those with you? If you want to take those with you, we need to make it clear. You want to put it in the MLS. You also want to make sure this is in the contract. I'm not necessarily one that would say take them down, because that goes to staging, right? That's what makes the property look appealing. It looks beautiful, right? If you were to take them down and put commercial grade or cap it, it doesn't look the same, right? That's why we consider staging. So I'm not the one to say take them down, but I am one to say make sure that it is clear that those chandeliers are not going with the property. Third thing, are tenants remaining in the property after closing? If they are, one second. If they are, clear. Had to clear someone's red marks off the screen. If there are tenants remaining in the property, be sure to let the title agent know right away. Here's why. Prorations for and credits for security deposits that have already been paid and rents that have already been paid. It's terrible when we get to closing date and they're like, well, what about the security deposit? There's no way for the closing agent to know there's tenants in the property unless told. So it's certainly a hot topic for buyer's agent, but it's important for the seller as well, because you don't want your sellers to get to the closing table and they're counting on, $100,000 in proceeds, but they have, let's say, $5,000 in security deposit that needs to be credited to the buyer. And they're saying, what? Nobody ever told me that. So make sure that you're aware, make sure the seller is aware, and make sure that the title agent is aware, so that that draft settlement statement can start coming out showing prorations and credits for security deposits that have already been made and for rents that have already been paid. All right. Now, likewise, in that same paragraph, you see at line 76, the contract itself specifically speaks to tenants remaining in the property. To address the seller remaining in the property post-occupancy, you know that we use a rider U for post-closing occupancy by the seller. Here's what I need you to know with that regard. Please, 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 please be clear on the terms of the post-occupancy at contract execution. Can you sort it out later? Sure. Do you run the risk of hitting a dead end and all of a sudden you guys are arguing about these post-occupancy terms? Absolutely. Here's an example. Seller will vacate the property at the end of the month. What is the end of the month? End of the month can be the 31st to the seller, but the 20th to the buyer. Believe it or not, I've seen that language before. Be clear. Be clear on the if there's going to be a fee or consideration for this post-occupancy, what is that number? Don't wait until you get to closing to start sorting that out. Because what if the buyer is asking for more than the seller is willing to pay? Now we have a problem. Let's sort that out at contract execution so that you can move on to another buyer if they're not willing to agree to those post-occupancy terms that the seller is requesting. Very important. Again, I only talk about what we've had to sort out at the closing table. Can the buyer assign the contract? Now, for those that are new, when you're not really clear on this term in the contract, this is paragraph 7. It starts at line 77 of the far bar as is contract. This is specifically saying, can the buyer who goes under contract with the seller then turn around and put someone else in their shoes as the buyer in that contract? The far bar contract provides 3 options. The first option is the buyer may assign and be released from further liability, meaning as soon as I put your name on this contract, Rashida, I'm gone. Seller, you got to talk to Rashida. I'm in Tahiti. If she doesn't close, I'm so sorry, right? The second option is I may assign, but I'm not released, right? So I put Ray Gordon instead of Ray Cole Jackson, and I go to Tahiti, but I need to keep my phone on me, because if Ray does not perform, Donna's calling me saying, well, Ray Cole, guess what? I don't know where Ray is, but I need you, Ray Cole, back in place because this guy didn't do what he was supposed to do. And then lastly, buyer may not assign this contract at all. It's important for you listing agents to understand what this provision in the contract means, because investors are doing it. And so we have that conversation. Well, when is it appropriate? When should I allow them to assign? I mean, all I care about is closing. Maybe, maybe not, right? Here's some considerations. Maybe you allow them to assign. You say that the buyer may assign this contract and be released from liability, or they may be assigned and not be released from liability, but you're specific. Say the buyer is saying, well, I have about 10 entities that I own, that I take title to my investment properties in, and I'm just not sure right now which one I want to use it. So you say, well, list the 10, and the option is those 10, and that's it. And you probably don't even want to say 10. You say pick your top 2. figure out the rest, because I'm not trying to have a conversation with you later on about someone else. Like I looked you in your eyes. I had a conversation with you. I'm okay with you closing. I don't want to now have to be having this conversation with someone else who just has a completely different posture and disposition. I mean, let's be honest. We get that, right? So, can the buyer assign the contract? Understand what that term means, and will you allow it? 6, did the buyer fail to act in good faith when they sent you that loan of that cancellation because the loan wasn't approved? Had this issue about 2 weeks ago. Oh, we didn't get our loan approved. We sorry. But there was information that the buyer never submitted the documents requested by the lender. That's failure to act in good faith. If you get that information representing a seller, you can have a conversation about default, because the contract clearly says that the buyer must use good faith. Let's look at line 92. They must use good faith and diligent effort to obtain an approval of the loan. Meaning they have to submit documents. If something needs to be signed, sign it. Your buyer can't just go silent, knowing that that's going to cause them not to get a loan approval. Wait for the lender to say you're not approved because we don't have information, and say, oh, sorry, we're canceling. You might be, you can, but we're keeping the deposit because you did not use good faith in getting that loan approval completed. So keep your eye to keep your ear and your eye on that communication to ensure that the buyer is in fact making diligent effort and using good faith to obtain a loan approval. Number 7, is there a deadline to conduct the appraisal? This is a big one, even outside of this market. You know that the contract itself does not provide a deadline for the appraisal to be conducted. But you know that unless there are specific provisions or an agreement terms in the contract, that in the event that the property does not appraise, now we're on shaky ground. Does seller need to lower the price? Is buyer canceling the contract? So for that point, as a listing agent, you should consider a deadline for the appraisal to be completed. You do not want to get all the way to closing, because guess what? They don't have to have the appraisal at any point prior to closing. There's no deadline. Unless you place in the contract, buyer will complete the appraisal within 10 days of the effective date of the contract. And that's not unreasonable. Here's a little provision in the contract that you probably never noticed. It starts at line 116. And this comes from the financing section of the contract. It says, if loan approval has been obtained or deemed to have been obtained as provided above, and the buyer fails to close this contract, then the deposit shall be paid to the seller unless failure to close is due to, let's jump to number 3. Appraisal of property obtained by buyer's lender is insufficient to meet terms of loan approval, in which event the buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. If it appraises for more, good job, Angie, you got a good deal. That's what we want as a buyer, honestly. We don't want that as a listing agent. And we're like, God, I missed something. You generally don't want that. You want all the juice out of that, right? You want it to appraise, but you don't want a huge disparity in the appraisal and the contract price. That's a choker, right? Like, oh my God, how did I miss that? But it happens. But here's the deal. Here's what I want to point out here. Guys, let's go back to the top. It says, if loan approval is obtained, you got a loan approval. Let's say the lender sends out a loan approval for, we got your income checks out, your credit score checks out. We get all the way to that point, but the condition on the loan approval is the appraisal. Meaning you've gotten past the loan approval contingency deadline, but the lender keeps on there as a condition the appraisal, and after that deadline, the property does not appraise. What does the contract say? The contract says appraisal of the property obtained by buyer's lender is insufficient to meet the terms of loan approval, in which event the buyer should be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. Do I need to tell you again? Get a deadline for the appraisal to be completed. Let's have this conversation early. All right. And then I get, oh, but I can't make, yes, you can. I even had an appraiser tell me, they can't yes, they can. If this is my agreement, I need you to figure it out, LO, how you get an appraiser out there 10 days prior, prior to this deadline. If you can't do it, then I need to go to someone else, because this is what I've agreed to, right? Number 8, this is common. Not super common, but you would be surprised. I get this question. Can the seller cancel the contract? Recall, my seller wants to cancel. My question is, for what? Let's think about this. They offer their property for sale. They put it on the market. What reason do you have to, you're under contract. What reason do you now have to back out of this contract? The contract, the Farbar as-is contract, does not provide for many opportunities, for good reason. You can't start this and not finish. So the only reason right now that the Farbar as-is provides for seller's ability to cancel the contract is if they're not able to deliver marketable title, but after reasonable and diligent effort. Generally, that's considered 30 days. So if there's a title issue and the seller already didn't want to sell, they changed their mind for whatever reason, they can't use that as a reason not to sell. You need to try and clear that title issue. That's what the contract says. It says if for any reason other than that, now they can't, if it's, let's use the probate issue, for example. They find out, for example, that a probate on the property prior to them taking title, or a probate that vested title in their name, was not conducted effectively. It should have been, maybe some other people should have been named. They find out that it's going to take 60 to 90 days to complete instead of 30. We can cancel. That's the title issue. And the buyer's not willing to wait that amount of time. We're canceling. The seller's not responsible. Outside of that, guys, unless you have some other built-in contingency, seller can't just cancel. They can't just wake up and say, oh God, I thought I was gonna be able to find a house in this market. You tricked me. Rashida, Jennifer, I'm not finding anything. I need to cancel. Guess what? Sorry, that's not a reason to cancel. Now, let's say your seller is just determined on canceling this contract. Are they liable for damages? Well, the contract says outside of not being able to deliver marketable title, they can't cancel. And their failure to or neglect to and refuse to perform under the terms of the contract, they're liable. And it says the buyer may elect to receive their return of their deposit without thereby waiving any action for damages resulting from seller's breach, and pursuant to paragraph 16 may seek to recover such damages or seek specific performance. For those who don't know, guess what specific performance is? That is, I am forcing you to do what you agreed to do, i.e. sell this property. You said you were going to sell. Now the court is going to enter an order, issue a judgment forcing you to sell. Does this happen all the time? No, because when you think about it theoretically, you are spending money. This is how I break it down to some people when they come to me with, running, I'm going to sue them. Okay, you're going to sue them. You're going to spend money to force them to allow you to spend more money. Okay. Now, if it's an investment property with a ton of equity in it, then yeah, now we're having a different conversation. I've represented buyers in those situations where the seller decided all of a sudden not to sell. They woke up, I don't know, however you want to describe it, and said, "Ooh, we should have sold this for more." You should have, but you did it. It was like $260 this is a ridiculous amount of equity in this property after repair value, and sued them. So the seller, they did proceed with a different transaction, but portion of that equity, their proceeds, were paid out to my client. So that's what specific performance is. Alternatively, or in addition to getting the buyer having their deposit returned, they can sue for damages. What is damages? This is what it cost me in this transaction intending to purchase this property from you. And we start from something as small as I paid for an appraisal, I paid for an inspection. Lost opportunity is damages. Now it's a lot to prove. You can easily prove your actual damages, right? Here are my receipts. This is what I paid. It gets a little tricky when you're trying to say, well, I missed out on an opportunity to make an offer on the property next door because I was under contract with you. But understand and know, realtors, that this is exposure for your seller. So when they start getting a little shaky, well, I'll just cancel. You tell them, hey, listen, not providing you with legal advice, but see line 333 of the contract and paragraph 16 regarding the buyer's recourse in the event you cancel without due cause. Lastly, should the seller consider attorney representation? You guys know in Florida, we have 3 options in the contract for who's selecting a title agent. You should know that unless specifically stated, the title agent is a neutral, meaning that the title agent, regardless of who selects the title agent, if there's not specific representation disclosed, the title agent is a neutral. The title agent isn't going to do anything to benefit the buyer to the detriment of the seller. Likewise, they're not going to do anything to the benefit of the seller to detriment the buyer as a neutral title and closing agent. However, in the event where you have seller representation, now obviously you can have buyer representation as well, but the more common situation is when you're seller, because you have executed the contract to allow for the buyer to designate the closing agent, the seller can then retain an attorney. This is what you guys need to be clear on. Unless the title agent is an attorney, the title agent cannot provide what we call seller representation services. They cannot. Only an attorney can provide seller representation services. And what happens in seller representation? I am fully, completely, 100% on the seller side. I'm not a neutral, all right? I'm going to make sure, I suggest, you have a relationship with a closing attorney, I suggest that you send that contract in that you're intending to accept before you accept it, before it's executed. I have seen some contracts, guys, that I was like, wow, we got a lot to clean up. We got a lot to clean up. What are we doing here? It was quite a few issues. And so if you have that relationship with a title attorney, consider having the title attorney review that, lay eyeballs on it before you execute it, to just make sure that everything lines up. Again, you're a realtor. You're looking at, making sure that the appraised value, you're looking at some of the basic terms. You're not necessarily always doing the legal eye thing, and you should not. This is why a relationship with a real estate attorney is productive. And so when does this happen? Again, used most commonly down in Miami-Dade and Broward. Buyer selects title agent. Seller can say, wonderful, they can be the closing agent, but I'm hiring this attorney to represent me in the closing. What does that mean? That means that the attorney is going to receive the searches. They're going to receive the title commitment. Everything that needs to be completed and provided on behalf of the seller will be done by their title attorney. Closing, they'll ensure that the seller documents are executed, delivered to the title agent. They'll ensure that funds are dispersed. Any questions, any legal issues arise. Again, the seller's representation is not neutral. Any legal issues arise, that title attorney is having that conversation on behalf of the seller, not you as a realtor, not the seller themselves trying to figure it out. They have specific representation. A quick question I have from Angie. What if closing date is set and buyer received clear to close 1 week prior and wants to move up closing date? Seller can refuse? Yes, they can. Yes, they can. Yes, they can. Can the seller refuse the earlier closing date? Absolutely. This is what I talked about, and I'm glad you asked that question, Angie. This is what I talk about in the contract class and even the anatomy of a transaction, where I talk about not using that on or before language. This is exactly the situation. You make an offer or you receive an offer, listing agent, you receive an offer from a buyer on or before July 31st. Great. That seems like a good idea to you until you have this situation. The buyer gets it clear to close 7 days before July 31st, and they're ready to close. And the seller's saying, hold on a minute, I'm not ready. And the buyer's agent points out, well, you said on or before. We're ready to close before. And the seller's saying, who did I said that? And seller said, well, I wasn't paying attention to that. I relied on you to tell me what to sign. If you've heard me before, what do I always say? Select a hard date. You can always agree to close sooner, later. You can always agree to close sooner, later. But you don't want this issue right here. Invariably, they're going to say, I didn't know what that meant. You just told me to sign, and I'm not ready to go. Sorry. Hang up. Right? Questions. Good questions, Angie. Good questions. Any other questions? Guys, feel free to chat. Feel free to type in the chat or come off mute. What questions do you have? Any questions at all? Again, didn't expect you to take notes. Just wanted you to, again, be cognizant of these. How long does the probate process typically take? It depends. Right now, we're coming out of COVID, so it's everything you're speeding up, and it depends on the type of probate case that you have. You have some probate cases that can go quicker than others. Thanks, Debbie. You have some probate cases that can move quicker than others, just by virtue of the what they call the amount in controversy, how long the decedent has been deceased, those types of matters, and they call those summary administration. Or you have full administration and they take longer. So the short answer is, Jennifer, it depends. But if you guys have questions regarding a probate sale specifically, or you have a client that needs probate representation, then obviously through the law firm Realty Law Group, we do have probate attorneys that can assist. Can a property be sold before? No. Before probate. So technically, if the court provides an order of sale and there's other matters that they're addressing, then there you go, Alicia. That's to answer that question. If there is an order issued, order authorizing sale, and it says you can sell the property now, we're dealing with, let's say they're dealing with some other personal property, boats and money and those types of things, then yes, you can. International probate property in Belize. Should I run from this property? Properties in Belize. I don't know anything about probate in Belize. I got to be very honest with you. I know a lot, but I don't know about a property in Belize, Gino. So do you recommend waiting for a clear from probate before listing? No, I would list it. Hey, always be marketing. You could get some buyers off of that while you're getting, let's think strategically. You could be having some conversations on that listing while that probate process is being cleared, as well as go under contract. As long as that person is willing to wait for the probate process to be completed, or at least an order authorizing sale, then you're good. Do you offer remote closings at other locations? Absolutely. We close all of Florida. We close all of Florida through our local offices, or we still use RON. We use mobile notaries, mailaways. We close all of Florida. We actually close the entire nation. We have people that sign in Tennessee. We have people that sign overseas. So the location of the parties is never an issue, ever, 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 ever. Don't ever think because our main office is in West Palm, we can't close something in Coral Gables, Doral. Port St. Lucie, Tallahassee, Jacksonville, wherever your buyers are, wherever your sellers are, there is absolutely a way to get them. Title comes to you. Yes, I'm the title attorney, Nicholas. So title does come to me. If I'm answering your question properly, figured you should ask. Yeah, you can ask. I definitely don't do beliefs. If request is made in court approval, it can occur. Yes, yes. If request is made and the court approves, yes, you can close before the full probate administration. Yes, we absolutely. Your office, your local real estate office can be for the day one of our closing tables. The statement was having locations in Broward and Palm Beach, but can close in our office or anywhere the client can choose. Listen, I've closed on the trunk of my car before. I did. I was like, listen, this is we're doing too much. Like I literally was giving the documents. I'm gonna go meet this guy and he can sign on the trunk of my car because this is for closing sake. Let's get this done. Let's get this done. Any other questions? So listen, in closing, the questions are going a little bit. It says, I have an odd situation where buyer keeps driving on the seller's property and trespassing. Whoa. Seller got very frustrated and told them to stop doing that. Seller has an attorney represent. What can seller do? Seller can call the police and have the buyer arrested. That is 100% trespassing. So you should tell them that and say, hey, listen, without providing legal advice, do know that that is a violation, that there is a law concerning trespassing, and the seller can call the police and have you arrested for trespassing. Short answer. Michael Horowitz is okay, it's moving. It's transferring the tenant's money held by landlord to buy as a credit on the closing statement, which reduces the buyer cash to close, actually a commingling. No, that's not a commingling. No, that's not a commingling. Commingling is literally, so say for example, you're managing property. Commingling is taking the tenant's rental monies or security deposits and placing it in your operating account, for example. That's not commingling, because and they're not. That's a good question too, Michael. They're not being given. Somebody is unmuted. I can't see it, but mute yourself. The buyer is not being given monies, as I indicated before, that's being placed in an account with their operating funds. They're being credited for monies that they're going to have to address when the the tenants move out of the property or whatever they have to do in managing of the property as the new landlord owner. That's a good question though. The rental contract due date ends on August 34th and is not to renew because the property will be sold. The notice of non-renewal has to be served 45 days before the contract ends. Technically, no, not 45, not unless the lease says that. You just have to give them notice, generally 30 days if it's the annual. But look at their lease agreement first. They may have specific agreement on when they will be given notice. Okay, not a problem. Sellers should have their own attorney or title company. Even the buyer suggests their title doesn't save the seller money at all. It saves the seller money to the extent that generally your seller rep fee is going to be about $850. Here's what it's saving your seller. Your seller has, I'm sorry, I'm just looking to see who's unmuted. Your seller has an attorney that's 100% representing them, right? When you have a title agent cannot, where else are you going to get an attorney to represent you in a matter for $850? It just ain't happening. So that's the average cost. Again, some charge more, but that's the average cost. Now, obviously, that's for a standard set of closing representation. If you get into litigation and you're getting into having to draft specific documents for issues that arose out of it, the attorney may charge a little bit more for their hourly, but generally those types of common issues are included in that representation. But again, this is one of most people's largest transactions in their lives and very technical. And I'm sure you guys understand the responsibility to interpret a contract. right? You don't want that responsibility. You don't want when they run into an issue, you have to interpret what their rights and responsibilities are, their remedies are, right? So why not grab an attorney, let them handle that? They help you as well, and we're set. Yep, exactly. Good to have seller representation as someone protecting their interests, reviewing the fees and costs that may end up saving them anyway. Minimal cost to be protected. Don't depend on the title selected by the other party. Um, Last question we have is seller has will with 9 individuals who have a share. Shouldn't she use her own attorney? Absolutely. Again, like was just indicated, to the extent that you can have an attorney that's going to represent you, dot every I, cross every T, confirm that that all your fees and interests have been addressed, why not? So one-time fee for peace of mind. All right. All right, guys. So in closing, outside the box education, outside the box results. Outside the box education, outside the box results. In order to be successful, in order to have extraordinary results, you cannot rely on the common education that's being provided. What do I always say? Real estate school taught you how to get how to pass the exam and get your license. It didn't teach you the business. It's not going to teach you all these nuances. They certainly didn't teach you the contract. And so you have to make an effort to subject yourselves and get outside the box education. Those that know more, those that learn more, they earn more. Competence equals confidence. As you become more and more competent in the contract, as you become more and more competent in the transaction process, as you become more competent in the listing process, as you become more competent in the comparison and appraisal and loan underwriting and all those other features of the service that you provide, you become more confident. You're not afraid of any question because you know you're competent. So outside the box education will give you outside the box results. Always go a step further in your education. It'll pay you back in spades, I promise. All right. With that, I'll see you guys next week. Next week is hot topics for buyer agents. Listen, thank you guys. Thank you guys. Ray, Jennifer, Tamika, Miss Jones, Gino, as always, Jackie, Oscar. Yes, Oscar is going to YouTube. Hey, Kimberly, thank you. Thanks, Kim. Elizabeth, thank you. Listen, without you guys, I'd be talking to myself. So I'm glad that you guys find value. Again, if there's a topic, let me go back to my email address, guys. If there's a topic, if there's an issue that you haven't seen that you'd like to see, shoot me an email, screenshot my email address really quickly. Shoot me an email, say, hey, this is a great, this is something. Who did I call out? Oh, Ray. I did. This is something that I'm having an issue with. I have questions about. Can we talk about this on one of the sessions, right? If it's for closing sake, we'll have that conversation. I'm always willing to have that conversation. Oops. Donna, thank you. Ruth, thank you. All right. All right, guys. I will see you guys later.